Okay, so a lot of people have been asking me to comment on the supposed hand signals that Judge Glanville and Attorney Hilton have been giving each other. So, at the risk of being extremely repetitious, I am going to leave this video looping here in the background. Also, I want to give credit to where I found the video. You can see the name of the TikTok account here. So if you want to give them a follow, I searched through all of the YSL trial footage that I could find. And for whatever reason, I just could not find this exact court date. So if you know what court date this was what day of the trial it was, and also if you have like a timestamp for me, please let me know in the comments so that I can do further investigation, because I literally opened all the court dates and didn't see it. So we're going to leave this looping in the background while we talk about what's coming up, what's happening with the recusal hearing. Where do we go from here? I'm going to read through the different court rules that are going to govern this recusal hearing, okay? So we're going to start off with Rule 25.1, and we're going to go through the rules here briefly. So Rule 25.1 says all motions to recuse or disqualify a judge presiding in a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for disqualification, and no later than 10 days prior to the hearing or trial which is subject of recusal or disqualification, unless good cause be shown for failure to meet such time requirements. In no event shall the motion be allowed to delay the trial or proceeding. So we're already past this part, right? The defendant, who's the plaintiff in the recusal hearing, that's the YSL lawyers, they have already filed. The state has answered on behalf of Judge Glanville. So now we're going to go to the next. The assigned judge may consider the motion solely upon the affidavits, but may, in the exercise of discretion, convene an evidentiary hearing. After consideration of the evidence, the judge assigned shall rule on the merits of the motion and shall make written findings and conclusions. If the motion is sustained, the selection of another judge to hear the case shall follow the same procedure as established in Rule 25.4 above. Any determination of disqualification shall not be competent evidence in any other case or proceedings. So basically what this is saying is that after Judge Cross, who has the proceedings under her care right now, she can either decide to call a hearing, have witnesses. She can decide to make a ruling based solely on the papers, as Doug Weinstein said. She can make a determination of how she wants to go about this. But after she makes her decision, if she does decide to remove Glanville, they'll have to select another judge based on Rule 25.4. So I guess that's going to be, we're not going to look at that rule, but it probably is just going to be like, a randomized judge. And also, this says specifically, if Glanville is disqualified, or if any judge is disqualified under this rule, that cannot become evidence in a further proceeding. So basically, you can't go back and say, well, in the next trial, you can't say, well, I want Glanville recused, and remember, he was recused from the last trial. So basically, this cannot become evidence against him. 25.7. If a judge, either on the motion of one of the parties or the judge's own motion, voluntarily disqualifies another judge selected by the procedure set forth in Rule 25.4 above, shall be assigned to hear the matter involved. A voluntary recusal shall not be construed as either an admission or denial to any of the allegations which have been set out in the motion. So basically, at this point, Glanville can still decide to voluntarily recuse himself from this whole matter, kind of put all of this to rest, put it all to bed. And if he does, that should not, according to this rule, that should not reflect negatively on him in the future. It should not set forth that he feels he had he had done anything wrong. He's not admitting any kind of guilt or admitting to having done anything inappropriate. He's not admitting to judicial misconduct. So that's still a possibility that at some point Glanville will simply step aside. So what happens if Glanville is removed? I'm going to put here a previous interview with Doug Weinstein in which he talked about just that. He gave the process for what will happen if Glanville is removed, whether he removes himself or whether Judge Cross decides he must be removed. So I'm going to put that here, and you can listen to what will happen next. Thank y'all for watching. And also remember, get back to me about this hand signal thing. What do y'all think about this? And what day was this from? And also, do you have a timestamp for me? Thanks a lot.
Okay. Can you explain both scenarios where the judge gets recused and one where he does not? What's next? And which is more likely?
Wow, that's a great
A long
question.
question, right?
Okay, let's do the judge gets recused first.
Okay.
If the judge gets recused, another judge is brought in to replace him. The law says that the case has to be unwound, basically, to the point where the first recusal was requested. I requested to at least that point. So I requested recusal on June the 12th. So a new judge will have to see if there's any way to unwind the case to Wednesday, June the 12th. I think that will be extraordinarily difficult, if not impossible, given that the jury has heard all kinds of evidence from Mr. Copeland. They've heard evidence based on judges' rulings on our objections. I don't know how you unwind this case, but the law says you have to try to unwind it. And if it can't be unwound, well, then that's grounds for a mistrial brought on by the actions of the state and the judge. What happens if the judge doesn't get recused? Well, there's potential maybe for us to be able to appeal that. If the judge doesn't get recused, the case carries on. It carries on.
Wouldn't there be some bad blood?
Well, we're all human, and you'd like to think the judge can put it aside, but yeah, we'll see if it gets there. That's an option that. Well, look, I wouldn't have filed for recusal if I didn't think it was merited, okay, and if I didn't think we had a strong case.
And if the case had to be rewound, Weinstein noted the potential difficulties with attempting to accomplish that.
All right. Our next one says, but if you also don't think the case will be rewound, then would that mean a mistrial? Or do you believe that that favors your client's case?
Well, if you can't really rewind the case, then a mistrial would be the only appropriate outcome at that point. Would that be in our favor? That's hard to say because I think so far the case has been going well for us. And I hate to see this whole thing start over again.
Yeah.
And the state have an opportunity to have learned. I mean, we all do things and then we learn from them and we do them different the next time. And I'm sure, we've all learned that have been involved in this case how to do things better the next time. So I don't know if I'm wild about giving the state another bite at the apple, but I also don't believe that it's right to continue on with what's happened so far in this case.